Tens of millions of Americans lived for generations under a quiet, normalized lie. A lie that said the Second Amendment was a right, but only if the government felt like honoring it. Only if you could persuade an official that you needed it. Only if you could prove your danger was special enough, your fear was specific enough, your life was valuable enough, your job was risky enough, your neighborhood was violent enough, your story was dramatic enough. And the most infuriating part is that this wasn't done by criminals. It wasn't forced on us by foreign enemies. It was built intentionally by our own state governments and enforced by bureaucrats behind desks in state capitals and licensing offices. People who treated the right to bear arms like a benefit program. A benefit you apply for. A benefit you can be denied. A benefit you can lose if you don't fit the profile. For over a century, that system didn't just regulate. It filtered. It selected. It excluded. It created a two-tier reality where rights operated one way for the connected and another way for everyone else. And it trained millions of Americans to accept a framework that should have been unthinkable, that the government gets to decide whether you deserve to exercise a constitutional right. Then the Supreme Court looked directly at that framework and said what needed to be said out loud. Unconstitutional. Not maybe unconstitutional. Not unconstitutional if it's too harsh. Not unconstitutional if it's applied unfairly. Unconstitutional in the structure itself, because the structure was built on discretion and subjective gatekeeping, exactly the kind of mechanism that turns rights into privileges. Now, if you're paying attention in 2026, you already know this isn't just a story about gun permits. It's a story about how rights work in America when a government decides it doesn't like one of them. It's a story about whether constitutional right means what ordinary people think it means, or whether it means right in theory, privilege in practice. And if you think that question doesn't apply to you because you don't own a firearm, you're missing the real lesson. Because once a government successfully converts one enumerated right into a permission-based system, it proves the concept. It proves that it can condition rights on bureaucratic approval. It proves it can demand you justify yourself first. And that logic doesn't stay quarantined to one amendment forever. Power never stops where it started. Before we go any further, I need to say something responsible and clear. Laws vary by state, and they are changing in real time through legislation and ongoing litigation. Nothing here is personal legal advice. If you carry or plan to carry, verify your state's current laws and consult a qualified attorney for guidance. The point of this is to explain what changed, what didn't, and why the confusion is dangerous. Because in a legal environment that shifts quickly, misunderstanding isn't harmless. It can be criminal. Now let's talk about the system that existed before the Supreme Court detonated it. For more than 100 years, several states operated under what was commonly called may issue, permitting for public carry. The phrase sounds technical until you translate it into normal English. The state may issue you a permit if it wants to, if it approves of you, if it likes your reason, if it believes you, if it decides your situation is exceptional enough. May issue wasn't just a permit requirement. Plenty of states have permits and still treat the right like a right. May issue was a philosophy. It was the idea that the state gets to ration the right, selectively, according to subjective standards. Under may issue, two people could have identical backgrounds, no criminal record, no disqualifying history, law-abiding adults, and one would get approved while the other would be denied. Not because one was more responsible, not because one was safer, but because one had a story that satisfied an official's personal threshold, or one lived in a county where permits were granted, or one had connections, or one had the right job title, or one had the right references, or one had the right last name. New York had the most infamous version, rooted in the Sullivan Act and its proper cause standard. Proper cause sounded like a neutral requirement until you saw how it worked. It didn't mean you passed a background check. It didn't mean you were trained. It didn't mean you were a responsible citizen. It meant you had to convince a licensing officer that you faced a specific, individualized, documented threat greater than what the general public faced. And that sounds, to some people, reasonable in the abstract until you ask the basic question, who decides what's enough? The answer was, a government official with enormous discretion. So if you were an ordinary person, if you were the night shift nurse walking to your car at 2 a.m., if you were the shopkeeper in a neighborhood where police response times are measured in good luck, if you were the single mother who had been harassed and wanted a way to protect herself, you were often told no. Your reasons weren't special enough. Your fear wasn't particularized enough. Your situation didn't rise to the level of being worthy of a permit. Meanwhile, the people who did get permits in the most restrictive places were often the people who least needed to plead. Celebrities, executives, politically connected individuals, people who knew who to call, people who could hire the right lawyers. People who could present a clean application with persuasive references and institutional credibility. For them, the system worked. It wasn't a barrier, it was a gate, and they had the key. That's what May issue really was, not a safety system, a class filter. And New York wasn't alone. California's good cause culture, while it varied by county, often functioned in the same discretionary way. In some counties, ordinary people had little chance. In some counties, permits were obtainable. That meant the same constitutional right could be practical in one county and almost fictional in the next. New Jersey had justifiable need, applied so restrictively that for years the number of civilian carry permits was tiny relative to population. Maryland had good and substantial reason. Massachusetts had a suitability framework that could turn your rights into a local police chief's personal policy preference. Hawaii issued so few civilian permits that the concept of lawful carry might as well have been a museum exhibit. Put together, these systems governed the daily reality of more than 100 million Americans, nearly a third of the population, who lived under a regime where the Second Amendment didn't operate like a right. It operated like a privilege you could be denied for not being special enough. And here's the part people forget. This wasn't a glitch. It wasn't a misunderstanding. It was the design. The goal wasn't simply to screen out prohibited persons. If the goal was merely keep guns out of the hands of felons and violent abusers, the system could have been structured around objective disqualifiers and background checks. The goal of May issue was to keep carry rare, to keep it socially and legally constrained, to reserve it for a narrow class of people, often those who already had power. Then came the case that took that structure and forced the Supreme Court to answer the question directly. Can the state demand you prove you have a special need before you can exercise the right to carry for self-defense? That case was New York State Rifle and Pistol Association versus Bruen, decided June 23, 2022. The facts were straightforward in a way that almost felt intentional. Two ordinary men applied for unrestricted concealed carry permits. They were law-abiding. They passed background checks. They wanted to carry for general self-defense. New York denied them because general self-defense was not proper cause. That denial put the constitutional issue in bright lights. The state was saying that even if you are a law-abiding citizen, you can be denied the right to carry unless you can persuade the government that your reasons are extraordinary. The Supreme Court rejected that. Justice Thomas, writing for the majority, made the core point impossible to miss. The Second Amendment protects an individual right to carry a handgun outside the home for self-defense, and the government cannot force law-abiding citizens to demonstrate a special need to exercise that right. Read what that means in plain language. You do not have to beg for a right. You do not have to convince a government employee that you deserve it. The Constitution is not a suggestion that becomes real only after an approval stamp. And it's worth pausing here to understand why that matters beyond guns. Think about how every other constitutional right works in practice. You don't need to prove your speech is important enough before you speak. You don't need a proper cause letter before you attend a church, synagogue, mosque, or temple. You don't need to justify why you want your Fourth Amendment protections before you refuse a warrantless search. Rights are not administered like favors. They are not dispensed like permits for the worthy. They are constraints on government power. That's the point. That's the architecture. Bruen essentially said, the Second Amendment is not a second-class right. It does not operate under a different philosophy than the First or Fourth. The government doesn't get to treat it as conditional simply because it makes officials uncomfortable. Now here's where the terminology matters, because people throw around phrases like they're interchangeable when they aren't. Bruen did not say every state must adopt permitless carry. That is one of the most dangerous misunderstandings in the gun community. Bruen struck down May issue special need regimes. It did not constitutionally mandate no permits at all. What Bruen did was force a shift to shall issue permitting in places that previously used discretion to deny ordinary citizens. May issue means the government may issue the permit if it wants to. Shall issue means the government shall issue the permit if you meet objective requirements. That difference is the difference between a right and a privilege. Under shall issue, the state can still require things like an application, fingerprints, background checks, and training in many cases. But it cannot deny you because it doesn't like your reason or because an official decides you're not special enough. This is where the modern fight moved, and it's why the story didn't end in 2022. In many ways, it intensified, because the states that lost in Bruen didn't surrender. They adapted. They changed strategies. They asked a new question. If we can't deny permits based on need, how do we still control carry in practice? And they found an answer. Make the permit less useful by expanding the map of prohibited places and increasing the procedural burdens. That's the post-Bruen playbook in one sentence. Now, before we talk about state responses, you need to understand the second half of what Bruen did, because the permit ruling, as important as it was, may not even be the most consequential part of the decision. Bruen also changed the legal test courts used to evaluate gun laws. Before Bruen, many courts used interest-balancing approaches, often described as intermediate scrutiny in practice. Under that framework, the government could defend a gun law by saying it serves an important interest like public safety, then producing studies, crime statistics, and policy arguments. In many jurisdictions, that became a very low bar. Public safety is always important, so restrictions often survived even when they were historically novel. Bruen rejected that balancing approach for the Second Amendment. It replaced it with what is often summarized as the text, history, and tradition test. In plain terms, that means when the government wants to defend a gun regulation, it can't just say public safety and win by default. It must show the regulation is consistent with the nation's historical tradition of firearm regulation. Courts look for historical analogs, especially around 1791, when the Second Amendment was ratified, and 1868, a key period for applying constitutional rights against the states through the 14th Amendment. This is why Bruen is still shaking the legal system in 2026. Because it didn't just change permits, it changed how courts evaluate gun laws across the board. Now courts are asking different questions. Is there a historical tradition of banning this category of arms? Is there a historical tradition of restricting magazine capacity? Is there a historical tradition of waiting periods? Is there a historical tradition for the way modern licensing rules are structured? Is there a historical tradition for bans in the specific types of locations the state is calling sensitive? And because modern gun control frameworks were built largely in the 20th century, many restrictions do not have clean founding-era analogs. That doesn't mean every law falls automatically. It means the government's burden is heavier, and courts must do more than rubber stamp public safety. This is why you see so much litigation post-Bruen over the entire universe of firearm regulation, because the standard changed, the rules of the game changed. Now let's make this concrete by looking at how states responded, because abstract constitutional tests don't matter to ordinary people until they show up as real rules in real places. New York was the epicenter, so New York's response was the most revealing. After Bruen killed proper cause, New York could no longer say, "We deny you because your reason isn't special." So New York passed a sweeping set of changes, widely described as an effort to comply while also limiting practical carry. That included expanded training requirements, new application procedures, and, most controversially, a broad expansion of sensitive places where carry would be prohibited, plus rules affecting carry on private property unless the owner affirmatively allowed it. The message behind the structure was simple. If we can't stop you from getting the permit, we can make it legally risky to use it in daily life. That response was challenged immediately, and courts have been sorting through which parts fit within constitutional limits under the Bruen standard, and which parts look like a disguised attempt to recreate May issue by other means. California's story followed a similar pattern. Before Bruen, good cause was the gate. After Bruen, the gate became harder to justify. So the state's response leaned heavily into a broad map of prohibited places and new procedural burdens. Again, the purpose wasn't necessarily to win a philosophical argument about rights. The purpose was to control carry in practice. New Jersey, which had justifiable need, saw dramatic changes once that standard could no longer survive. Permits that were once rare became obtainable for ordinary people who met objective criteria. Maryland's good and substantial reason went away and the structure shifted. Massachusetts' discretionary suitability framework faced heavy pressure because when local officials can decide who is suitable, the system begins to look like May issue under another name. Hawaii's near-total refusal to issue permits was incompatible with the recognition of a public carry right. The notion that the Second Amendment simply doesn't apply because of geography was not accepted. Now, if you live in a state that was already shall issue or already had permitless carry, you might be tempted to shrug and say this was all about those states. It wasn't. Bruen matters everywhere for two reasons. First, it sets a constitutional baseline against sliding back into discretionary denial. It doesn't mean your state can't regulate anything, but it does mean the old prove special need gatekeeping is constitutionally toxic. Second, the text history tradition test applies across the country. That means legal challenges in one jurisdiction influence how courts think and rule in others. It means gun laws in your state that were previously defended under interest balancing may now face a tougher constitutional environment. Now we need to talk about the post-Bruen trap that could get a law-abiding person arrested. The sensitive places explosion. Bruen acknowledged that some sensitive places exist historically, like schools and government buildings in certain contexts. The dispute is not sensitive places can never exist. The dispute is how far a state can stretch that label. After Bruen, some states tried to stretch it extremely far, so far that the list of prohibited locations began to look less like a safety carve-out and more like a carry ban written as geography. This is where people misunderstand what a permit means. A permit does not mean you can carry anywhere. Even in gun-friendly states, there are restrictions. Federal buildings, secure areas, schools in many contexts, courts and other locations regulated by state or federal law. Those can carry serious penalties, and they remain enforceable. In post-Bruen restrictive states, the prohibited map expanded so dramatically in some places that you could be a law-abiding permit holder and still commit a crime by entering a park, stepping onto public transit, going into certain entertainment venues, entering a business with unclear signage, or walking into a place the state has deemed sensitive. That's why you can't treat Bruen change the law as permission to stop paying attention. In a rapidly changing legal environment, what matters is the law in force in your specific jurisdiction at the moment you're carrying. A federal judge may have enjoined something. An appeals court may have stayed that injunction. A law may be partially blocked and partially in effect. If you're relying on a summary from last year, you can be wrong in a way that carries criminal consequences. Another post-Bruen battleground is the attempt to bring subjectivity back through character standards and broad disclosure requirements. If a state says, "we shall issue now," but still uses vague criteria like good moral character or suitable person, the practical question becomes, who decides what that means and how much discretion do they have? Because if an official can deny you based on personal judgment, the state has essentially rebuilt may issue without using the words proper cause. Some jurisdictions have experimented with broad disclosure requirements and, in some cases, social media review concepts. The underlying concern is the same. Does the state get to treat the permit application as a personality test? Can a licensing officer deny you because they dislike your politics, your jokes, your tone, your associations, or a post from years ago that they interpret as poor judgment? Those fights are working their way through the courts, and outcomes depend on how specific laws are written and how judges apply the Bruen framework. But again, the practical message is simple. Follow the current law while challenges play out, and don't assume "I think it's unconstitutional" will protect you from arrest. Now, because misinformation spreads faster than the law changes, I want to clean up 3 myths that have been spreading inside the gun community since Bruen, and each myth can lead to serious consequences if you believe it. The first myth is that Bruen means you can carry without a permit everywhere. That is false. Bruen did not mandate permitless carry nationwide. It held that may issue discretionary denial is unconstitutional. If your state still requires a permit, you still need a permit. Do not carry on the assumption that the Supreme Court made permits optional unless you have verified your state's law right now, not from a meme, not from a friend, not from an outdated chart. The second myth is that all gun-free zones are now unconstitutional. Also false. Sensitive place restrictions still exist, and some have historical grounding and are likely to remain enforceable. The fight is about overreach and modern expansions that lack historical analogs. But until a restriction is struck down or enjoined in your jurisdiction, it can still be the law. The safest legal posture is to treat posted and codified prohibited places as real. The third myth is that background checks and training requirements are gone. They are not. The court's core objection was to subjective discretion and special need requirements. not to objective vetting. Many shall-issue regimes include training, fingerprints, and background checks. The constitutional problem arises when those requirements are used as a disguised denial system. When delays become punitive, costs become exclusionary, or vague standards become a veto. Now step back and look at the bigger legal arc, because Bruen is part of a progression, not a one-off event. In 2008, District of Columbia versus Heller recognized an individual right to keep and bear arms for lawful purposes like self-defense in the home, rejecting the idea that the Second Amendment is only about organized militia service. In 2010, McDonald versus Chicago applied that right to the states through the 14th Amendment, meaning state and local governments couldn't simply ignore it. In 2022, Bruen confirmed that the right includes public carry for self-defense and imposed a history and tradition framework that reshaped how gun regulations are judged. That trajectory matters because it shows the direction courts have moved, from recognizing an individual right to applying it against states, to expanding its protected scope and tightening the test for restrictions. And in 2026, the practical reality is that litigation continues to test where the boundaries are. The constitutional floor is higher than it was a decade ago, and the shape of future rulings will determine whether states can recreate old control mechanisms under new labels. Now, I want to bring this down to the principle underneath all of it, because this is where people either get it or they don't. Self-defense is not a partisan identity. It's not a political brand. It's not a cultural signal. It is a fundamental human interest, the right to protect your life. For a long time, May-issue states turned that interest into a permission structure that ordinary people could not reliably access. The wealthy and connected navigated it. The vulnerable and ordinary were filtered out. That matters, because it exposes the moral and practical truth of discretionary permitting. It does not distribute safety. It distributes permission, and permission tends to follow power. Bruen said that has to stop. The Second Amendment is not a VIP perk. It does not evaporate in cities because officials dislike it. It does not bend to the personal preferences of licensing officers. It does not apply only to people with the right resume and the right references. It applies to law-abiding citizens broadly, and the state cannot require you to prove you are more deserving than everyone else. So what should a person do with this reality in 2026 when the legal landscape is still shifting? First, treat being uninformed as a genuine risk. Ignorance is not a defense, and in an era where laws and injunctions can change quickly, relying on old summaries is dangerous. Know your state's requirements, and if you travel, know the states you travel through. If you carry, know prohibited locations and the current status of major restrictions. Verify through reliable sources. Stay current. Second, understand that this is a marathon. Bruen established the constitutional baseline, but the dismantling of decades of restrictive structures happens through continued litigation and state responses. Some parts of the post-Bruen resistance strategy will fail. Some will survive. Some will be narrowed. Some will come back in new forms. This takes time. Third, recognize that rights can be discouraged even when they are recognized. States can make processes expensive, slow, confusing, and socially fraught. They can make the right technically available, but practically hazardous. The people who care about rights have to defend them legally, culturally, and practically, by exercising them responsibly and refusing to let lawful conduct be reframed as extremism. Fourth, if you carry, do it responsibly. Get trained because you value competence, not because someone forced you. Understand lawful use of force standards. Avoid prohibited places. Keep your behavior boring, predictable, and lawful. One reckless incident becomes political ammunition for sweeping restrictions. Now here's the bottom line. In plain language, May-issue special need permitting is constitutionally dead after Bruen. If your state used to require you to prove a special reason, you can no longer be denied simply because a bureaucrat doesn't like your reason. Shall issue means objective criteria, not subjective worthiness. And the biggest shift isn't only about permits, it's the standard. Gun laws now face a text history tradition test rather than interest balancing. And that is why so many laws are being challenged and why outcomes are still unfolding. At the same time, none of this means anything goes. Permits may still be required depending on your state. Sensitive places still exist. Training and background checks may still be required. The danger comes from assuming the Supreme Court gave you a blanket permission slip. It didn't. It gave you constitutional ground, and the fight now is how much of your daily life states can wall off anyway. That's the truth of 2026. Rights expanded? Yes. But so did the complexity of the battlefield. If you want to stay safe and stay legal, you don't live off headlines. You live off current law. You verify, you adapt, you don't guess. Because the gap between ignorance and knowledge is the gap between believing you don't have a right and quietly surrendering it versus knowing the law changed and actually being able to exercise it responsibly within the rules that exist today. Stay calm, stay current, stay legal.